Tiffany Martinez. So what are we here for on this case?
Judge, this is the second setting she's had since she's been indicted. The case took over a year to indict. We're still waiting on discovery and trying to get that together.
Okay,
So we're just asking for one more setting to be able to do that.
all right, and so discovery.
As far as I'm aware, Your Honor, all the discovery has been tendered in
Well,
Uh-huh,
I just
yeah.
had a notice of additional stuff last night, so.
All right,
done
so
with a
this
little
is gonna be the final discovery date. States, you need to make sure that everything is uploaded.
Yes, Judge.
Ms. Ferguson, if you'll put this at the end of January, all right, January 28th. All right, thank you.
Judge.
You're welcome. Once you sign the reset form, you're excused. And thank you for dressing appropriately for court. April Perez. Who's the attorney for April Perez?
Present for Judge.
Thank you.
We're here for a plea deadline, Judge.
All right. Good morning. All right, so is there gonna be a request for jury trial?
Yes, Judge.
All right, how long do y'all expect this trial to last?
It's a possession case, there's two officers and I guess a live person.
All right, Ms. Ferguson, I need a jury trial date. It's a drug case. They're saying 2 days.
I believe I may need to bench warrant a person that was there at the scene in the vehicle with her.
All right. All right, your jury trial date is gonna be January 21st. The court will not accept any plea bargaining agreements without good cause, otherwise you have to plea open to the court. Do you understand? Okay, and if you all can make sure that an acknowledgement of discovery has been completed.
Yes, Judge.
All right, thank you. All right, after you sign the reset form, you'll be excused. Okay, thank you. Bradley Gowlon.
Yes, Judge. Present for him, he's here.
Okay,
This is a case where we had previously had a motion to suppress. We're waiting for
Lily.
a ruling from the Court of Criminal Appeals. I don't believe one has come
Yes.
back down yet.
All right, what we'll do is we'll set this for the end of January as well, for the same date. What would, let me see. All
The 21st?
right, we'll set it for the 21st.
Okay, Judge, thanks.
All right, thank you. Norma Gallon.
And is that just for I guess, a status or?
Yes. Excuse me, did somebody say they wanted a jury trial on Christmas Eve?
Just the early Christmas gift.
A one day trial?
Raymond.
The next defendant has 41 criminal cases and 33 arrests in just Bexar County. He changed his name from Even Scott to Raymond McKinney. Has he learned how to outsmart the district attorney's office? He is gonna complain about his attorney. While I understand what he is complaining about and have noticed this with public defenders in this county, it's hard to have sympathy for someone with this criminal history. Yet, his method has been working. His criminal history and arrests are gonna take a bit, so please mute and fast forward about 5 minutes if the reading bothers you. Please remember, it's for those with vision impairments or for those listening and not watching.
Raymond Lee McKinney aka Even Scott, age 43. 2024 unlawful possession firearm, BY felon bond $15,000 offense, and arrest date. The 19th of September 2024. 2024 manufacture, deliver controlled substance penalty group equals 4 grams to 200 grams. 2024 possession, controlled substance penalty group 1B equals 4 grams to 200 grams, bond $15,000 offense, and arrest date. The 19th of September 2024. 2024 unlawful carry weapon, with felony convictions from bond $20,000 to remand without bond offense, and arrest date. The 14th of June 2024. 2024 manufacture, deliver controlled substance penalty group 4 grams to 200 grams bond $20,000 offense, and arrest date the 14th of June 2024. 2022 failure to identify to police officer with Texas warrant dismissed, insufficient evidence. 2022 assault emergency services person bodily injury dismissed, insufficient evidence. 2021 possession, with intent to deliver controlled substance penalty group 1 gram to 4 grams dismissed, further investigation. 2021 aggravated robbery dismissed, insufficient evidence. 2021 obstructing passageway roadway had narcotics, and failed to give his name, when asked numerous times dismissed, insufficient evidence. 2020 possession marriage under 2 ounces, declined to prosecute. 2020 obstruct passageway, a roadway dismissal created in error. 2020 failure to identify to police officer false or fictitious information dismissed, insufficient evidence. 2020 possession controlled substance penalty group 1 less than 1 gram dismissed, other. 2017 possession controlled substance penalty group 1 less than 1 gram, 197 days jail. 2017 felon possession firearm dismissed, defendant convicted other. 2017 theft firearm dismissed, defendant convicted other. 2017 violation bond, a protective order pretrial supervision terminated, unsatisfactory dismissed, defendant convicted other. 2017 possession, controlled substance penalty group 3 less than 28 gram dismissed, other. 2017 possession marriage less than 2 ounces dismissed, other. 2017 driving while intoxicated dismissed, insufficient evidence.
2016 assault bodily injury, sentenced to 1 day. 2016 assault bodily injury married, dismissed, missing witness. 2016 criminal mischief $100 TO $750 broke driver side car window with his fist dismissed, missing witness. 2016 possession Maria less than 2 ounces dismissed cannot prove beyond reasonable doubt. 2012 possession controlled substance penalty group 1 less than 1 gram dismissed, missing witness. 2012 possession controlled substance penalty group 1 less than 1 gram enhanced habitual, guilty by jury, sentenced to 12 years deferred, but appealed and got it dismissed. 2012 possession with intent to deliver controlled substance 4 grams to 200 grams dismissed, defendant convicted other. 2012 assault bodily injury dismissed, defendant convicted other. 2011 possession marriage 0 to 2 ounces, sentenced 45 days jail. 2010 possession controlled substance penalty group 3 less than 28 gram dismissed, guilty different charge. 2010 possession marriage 0 to 2 ounces dismissed, guilty different charge. 2006 assault public servant bodily injury sentenced to 4 years in 2008 with 389 days credit, released TDCJ the 26th of February 2009. 2006 possession controlled substance penalty group 2 to 4 grams to 400 grams, concurrent with the sentence above. 2006 resisting arrest search transportation dismissed, defendant convicted other. 2006 evading arrest dismissed, defendant convicted other. 2006 possession marriage 2 to 4 ounces dismissed, defendant convicted other. 2005 possession marriage 0 to 2 ounces dismissed, insufficient evidence. 2000 possession with intent to deliver. Controlled substance penalty group 1 to 4 grams to 200 grams dismissed, defendant custody elsewhere. 1998 failure to identify to police officer with Texas warrant, sentenced to 4 months, served 48 days. 1998 criminal trespass private property dismissed, guilty different charge. 1998 possession marriage 0 to 2 ounces, concurrent with previous sentence, served 50 days.
Kenny?
Judge, I'm present on that, Judge.
Okay,
Judge, I've been confirmed with Megan.
all right, Megan?
So Judge, this is a case I took over for Tony Jimenez. He had withdrawn. There was an additional file that was filed under a AKA.
Mhm.
And I need some additional time to go through all the discovery and then figure out what motions to file. And then also to file a speedy trial motion. But I asked for, the last time we were here, I think they couldn't find the files. They found 2 of them and the other one is under a different name and they're going to get that one too. But I think we should have all the discovery.
All right, so does he only have 3 cases?
That's my knowledge, yes.
All right, so you have all the discovery?
My understanding, yes.
State, were you able to tender an offer?
There's one in the file, Your Honor.
All right, so what I'll do is I'll set it for a plea deadline date.
No.
Counsel, how much time are you asking?
I'd say 60 days if I could, Judge, so I can go through all this stuff. I'm pretty backed up in January, particularly in this court.
All right, Ms. Ferguson, if I can have a 45-day reset for a plea deadline date on McKinney?
Very Solomonic split the difference.
See, there you go.
I can do February 3rd.
All right, February 3rd, that's when we'll bring you back. On that date, you need to let the court know whether or not you've reached an agreement with the state. Do you understand?
Yes, I understand.
All right, do you have any questions about anything?
Yes, ma'am.
Sure.
Judge, if we could we do the 4th? I'm set on the jury docket in Atascosa and district court. I don't think I'll go, but I'll need to announce.
Norma, can you put this on the 4th?
Yes, ma'am.
All right, thank you, Judge.
And you said you had something you wanted to say?
Yes, ma'am.
Have you cleared that with your defense attorney to see if it's appropriate?
Judge, if he wants to speak, I have no problem with that.
All right, yes.
Thank you a lot. And if you would, may I please establish this on the record, please?
Oh, sure. We're going on the record in 2024 CR 009238, 2024 CR 012230, and 2024 CR 012200, State versus Raymond Lee McKinney. Could I have parties announced for the record for the state?
Megan Galloway for the state of Texas.
Robert Mauer for defendant.
And are you Mr. Raymond Lee McKinney?
Yes, I am.
All right, there's something you wanted to address?
Yes, ma'am, it is. I want to bring to the court's attention from the onset and cause number 2024 CR 009238. From the onset, I have expressed my desire with the attorney before, Antonio Jimenez, in addition to Mr. Robert Mauer, my wish to proceed in the fastest fashion possible.
Okay.
In addition to that, with the other causes or case numbers, 2024 PF 1622 4 and 2024 PF 16225. I've done the same, considering Mr. Maurer has been the attorney in those matters solely. Here it is. It's from the June case in CR 009238. I've been pending prosecution since June 14th to be exact. And even with the court, with the presiding, I have expressed same assertions. And I'd like for the record to reflect that I insist on moving as fast as possible. I understand that Mr. Maurer here has other matters, but I mean, I'm constantly being put at the back end of those matters or at the bottom of the totem pole, so to say. So if the court would, no disrespect to Mr. Maurer, I'm pretty sure he's a swell attorney. Provide me somebody who could aid and assist me in the matters as speedily as possible.
Judge, I would have no objections to withdrawing. I tried 3 cases in the last 2 months that are jail cases, including a murder case and a sexual assault. So if you want somebody else, Judge, I would be more than happy. There are many able attorneys that I'm looking at in this court who would do a great job on this case.
All right. I appreciate that. Let me explain.
again, I
something.
mean-
No. Let me explain something to you, Mr. McKinney.
Yes, ma'am.
I understand what you're saying. And the state of our society has always been that there are always people who are alleged to have committed offenses. So I want you to turn around and look behind you. No, turn around, turn around, look behind you. All of those people are defendants who have cases on the docket. Look in the box. All those people have cases on the docket. There are cases that are capital murder cases that are set for trial that are ahead of yours. So even if your attorney were to say, I want to go to trial today, number one, we can't go today. Are there jurors even today? There are no jurors scheduled because they're taking time off for holidays. So even if you wanted a jury trial today and I was able to give you one today, I can't because I don't have any jurors. And what I can tell you is the inmates in the box cannot be on your jury panel. I think the state would probably object to them. The defendants in the gallery, they can't be on your jury. I think the state would probably object to them. And legally, because they're not a part of the rotation and they haven't been called up for jury duty, they can't be on your jury panel. So I don't even have jurors to go to a jury trial today. What I can tell you is this court is a trying court. And I think the defense attorneys and the prosecutors will tell you, we're usually in jury trial almost every week or every other week. Your case, while I know you feel it's old, it is not old for the criminal justice system. And your case, the first time that I had you in this court was October 29th. And then an attorney withdrew and your attorney on November 7th was actually in a jury trial. He can't be in 2 places at the same time.
But at that time, October 29th, he had asked for the court to grant him a reset for the next day, which would have been October 30th.
He's in jury trial. Let me ask you this. If you have somebody who's in jury trial, and I will tell you, he's on the 3G list. So he's not trying the state jail felonies, of course, unless somebody wants a trial on the state jail felonies. The cases that he is trying are major cases. They're like murder cases. They're like 3G sexual assault cases. So the question for you is, do you understand that defense attorneys need a break too? Like putting them to trial for 1 week and they finish on a Friday and then you say your next trial is on a Monday, they need mental health breaks as well. I've been a defense attorney, I've been a prosecutor. Even prosecutors need mental health breaks. So I think you want your attorney at his top performance, and part of being at his top performance is not being in back-to-back trials, which is what has happened with your attorney. You understand?
No,
So
I understand
what we're,
fully.
this is what is gonna happen. On February 4th, that's gonna be your plea deadline date. Either you worked out an agreement with the state or you have not. And then after that, you are getting a jury trial date. Can I give you a jury trial date in February? Yes, I can, but guess what? It's probably not gonna go because we have a capital murder that the beginning of February. And then guess what? After that, we have a murder case. Then we have another murder case. Then we have another murder case. So I will put you in order as far as length of time that you've been in custody and whether or not you come up first before the other cases. Do you understand?
I understand if you may,
All right.
if you may, now please say one additional
Sure.
thing, please. And so I don't get this misconstrued or mistaken, speak. May I please grab what I'm finna say out of my photo, please?
I'm sorry, what?
May I please grab what I'm finna say out of my photo?
All right, what are your plans to say?
It's in regards to law.
All right, so
I don't want to mistake it.
all right, here's the thing. There is nothing that I can give to you. Sometimes I ask people, what is it specifically you want? So what I've determined from your questioning me is you want a jury trial today. It's not happening.
That's not what I'm saying. What
All
I'm
right, do
saying,
you want a jury trial as soon as possible?
that's what I've been.
We will
asking
give
for.
you one as soon as possible. So thank you very much, okay?
But again, dear judge, again, a backlog case is not justification to.
Judge, may I be excused?
deny me
Yes,
thank
the
you.
awarding of my speedy trial.
All right, thank you.
Okay. No, it's okay. I appreciate it.
All right, Christopher Buenoteo. All right, court is calling 2024 CR 2440, State versus Christopher R. Buenoteo. Could I have parties announced for the record for the state?
Jayson Garrett,
Defense?
Dwight Chumley.
And are you Mr. Buenoteo?
Yes, Your Honor.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Christopher Buenoteo who was placed on community supervision in 2024 CR 2440 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on March 28, 2024 for a term of 3 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor, violated condition number 39 on or about the 22nd day of November 2024 in Bexar County, Texas. The defendant Christopher R. Buenoteo within and there failed to comply with the rules, regulations, or instructions of the Deferred County Community Supervision and Corrections Department's duly diagnosed residential facility, and that the defendant was unsuccessfully discharged due to program refusal in violation of condition number 39.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition 39, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility? Knowing that, do you still wish to plead true to violation of condition number 39? Court would find that violation of condition number 39 true. Is there proposed agreement?
There is, Your Honor, and it is to grant the motion, revoke the individual off his community supervision, and to sentence him to reform the underlying sentence of 2 years to 9 months.
It's our agreement, Your Honor.
All right, so why should I just sentence him to 9 months when he refused to participate?
Well, he has an issue with rehab because he doesn't feel like he is an addict and that he doesn't need the care. My experience over the years is if someone doesn't want care like that, that it's not going to do much to make him go through it. And I
I think that's what Mr. Monteo's position is.
All right. All right, the court is going to grant the motion, revoke you. The court will sentence you to 2 years in the state jail facility, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you were on community supervision. Because this is a plea bargaining agreement, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you.
And that's 2 years with the back time?
Yes, you'll get credit for any time that you were in custody. All right, thank you. Alex Casas. All right, so today was supposed to be plea deadline date.
Actually, Judge, we have a phone dump that we didn't realize we had previously. So we needed an opportunity to give defense counsel a copy. So I just needed to do that. So I don't know if we can have one more discovery setting, short setting.
All right, Norma, if you recall this for plea deadline date for that first week in January, please. All right, January 9th. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court. All right. Rene Camarillo. And I think you all just finished jury trial.
Yes, Your Honor.
I did, yes. We finished on Friday.
So, you all need a jury trial date, correct?
Correct, Judge.
Judge, sorry, I talked to Norma, we picked a date already,
Yes.
if that's okay.
Yes.
It's June 10th, 2025.
All right, we will bring you back on June 10th, 2025. That's the earliest date we have available for a jury trial date. If something opens up sooner and they want to come back sooner, then we'll bring you back sooner. Do you have any questions? All right, you're going to be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you need to speak to your attorney. And counsel, if there's an issue with the clothing exchange, just let the court know.
Thank you, Judge. I appreciate it.
All right, thank you. Javier Rodriguez. All right, hello. Today is plea deadline date.
Yes, Your Honor. I'm here for Mr. Lauda. He's in juvenile court. He had spoken to the prosecutor previously.
Yes.
They have approved him for pretrial diversion.
All right, Ms. Ferguson, can I have a date for PTD, please? All right, January 28th. Make sure everything is filled out, okay? All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. Macedonio Claudio Jr.
That's better than me.
That's almost Greek, the first name.
I always, I gotta look to see where the comma is, to see what the first and last.
Oh, yeah. All right, so where are we on discovery?
We have all the discovery, we have the lab, we just need time to review that, Your Honor.
Okay. State, were you able to tender an offer or no?
No, Your Honor.
All right, so Norma, give me a 30-day reset and state at that time an offer will be due.
Yes, Your Honor.
I can do the
All right, January 16th. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Judge.
Thank you.
Will you be around this afternoon or tomorrow?
Yes.
Okay, I just have to formally present.
Okay,
So
sure.
it's-
No, no,
Okay,
no
thank you.
problem.
I just want to make sure. Thanks, Judge.
All right, Jayson Andrade. And counsel, is this an application?
It is.
All right, probation, this is an application. Court is calling 2024 CR 009620, State of Texas versus Jayson Anthony Andrade. Could I have parties announced for the record for the state?
In Galloway for the state.
Defense?
Bud for the defense.
And are you Mr. Andrade?
Yes, ma'am.
Counsel, have you received all discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Counsel, is this going to be an application for deferred or no?
Yes, Judge.
All right. Mr. Andrade, did you review the document entitled application for deferred with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Andrade, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with harassment of a public servant. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, there's a $2,000 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 120 hours of community service restitution, a mental health evaluation, anger management course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Just follow the agreement.
All right. Mr. Andrade, have you ever been diagnosed with any mental health issues?
No, ma'am.
All right, so what caused all of this?
Just, I was drinking alcohol at the time. I recently stopped drinking alcohol due to the fact that I don't know how to handle it when I drink.
All right, are you employed?
No, ma'am, not currently. I'm currently in school, in a trade school to be an electrician.
Okay. So how do you support yourself?
I have family support me.
Do you have any children?
I have a baby girl on the way. She's doing me.
All right, this is what the court will do. There's a $2,000 fine that's to be probated, MIC evaluation, and TAP evaluation out of custody. Follow recommendations. If the recommendation from TAP is inpatient treatment, we can have a hearing in regards to that, counsel.
Sure.
Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be 120 sober meetings in 120 days. 5 years deferred adjudication. 120 hours of community service restitution. 20 hours will be deducted upon completion of parenting classes. The remaining 100 hours will be deducted once you've obtained your certificate from trade school.
Yes, thank you.
There's going to be field visits 1 time per month for 6 months. There is to be regular random UAs. Make sure they test for alcohol and regular reporting by Zoom or in person and anger management course. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, we can go off the record. You obviously have an alcohol problem, right? So you're one of those people in the population who cannot drink at all. Do not backslide. If you have an issue or you need help with anything, or you feel like you're going to use alcohol, because while you're on probation, you're not allowed to drink alcohol, even at your home, pick up the phone, call probation. They'll try to get you some help. If you feel as though they're not addressing issues you have, you can always come back to the court, okay?
Talked to hotlines too before. I've called them, they've helped me, so I've stopped it and all that.
All right, good. All right, good luck to you. Thank you for dressing appropriately for court, and probation will go over conditions with you.
Thank you, Your Honor.
Thank you. Who's here on David Villarreal? And counsel, is this an application? All right. Probation, there's no application. Court is calling 2024 CR 011631, State versus David Villarreal. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Bill for the defense.
All right. And are you Mr. Villarreal? Counsel, have you received all discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we are waiving the repeat offender enhancement.
And no objection.
Right.
And he also has an MTR.
Okay. All right, I'll get to the MTR
Okay.
after this. Did you understand you're charged with theft of property, 2,500 to 30,000 as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
No.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Villarreal, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
According to the plea, punishment is to be assessed at 14 months in the state jail facility. There's a $2,000 fine, no applications. This is to run concurrent with DC 2024 CR 2759. Did you understand that to be the plea?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
We would just like for you to follow the agreement on both this case and also on the motion to revoke probation.
All right. Court will find you guilty, sentence you to 14 months in the state jail facility, give you credit for any time served. There's a $2,000 fine. Time and money is to run concurrent. This will run concurrent with 2024 CR 2759. There's to be restitution, if any, and no contact with Alyssa, ALYSSA, Bon, BON, Cantu. There's to be no contact with Jacob, Matthew Alderete. Court is proceeding on 2024 CR 2759. Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it? Are you the same David Villarreal who was placed on deferred adjudication for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on June 24, 2024 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Judge, the state wishes to proceed on violation of condition number 1 on or about the 9th day of August 2024 in Bexar County, Texas. The defendant, David Villarreal, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
No contest.
I'm sorry.
You have to plead either true or not true.
No.
Oh, you're pleading not true?
On that case, yeah.
I believe that case is the case that you just pled to and I sentenced you. Is that correct?
It is correct.
Do you want to discuss that with him?
No, go ahead.
No. I want it.
Sorry
I don't
about
want
that.
you to be confused about anything.
Sorry about that.
So, no. No need to apologize. So what you just pled to?
Was that, yes.
Yes, theft. Now, in the motion to revoke, the state is alleging that theft in the motion to revoke. So you can either plead true to it or not true. That's completely up to you. I'm sorry?
It's true.
All right, do you understand everything?
Yes, ma'am.
And counsel, has he been able to understand everything?
He has been.
All right. So state,
You waive and abandon the remainders, Your Honor.
No objections.
all right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to $10,000 fine and up to 2 years in the state jail facility? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It is for the court to grant the state's motion and turn adjudication of guilt against the defendant, revoke his community supervision, and sentence him to 14 months in the state jail facility concurrent with the case. That's 2024 CR 011631.
I'm sorry, 631.
631.
All right, has he done anything on probation
Um,
other than the new offense?
I think he reported one time and spoke to his probation officer. Then he became homeless after that. And he lost his phone and had all sorts of difficulties. So I don't think he ever went back and saw his probation officer again.
All right, probation.
Yes, Judge.
Did he ever obtain employment and report it to probation?
No, Judge.
Did he ever report his sober support meetings?
No, Judge.
Did he ever report? Would you like to let the court know what you've done?
I haven't.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. You're gonna have to make sure you keep your voice up. You're David Villarreal?
Yes, ma'am.
All right, did you ever report?
Yes, ma'am, I did. Just one time I spoke to my probation officer. We had a very good conversation. Everything was great. And at the time I was using my mother's number, her phone, and she actually kicked me out of the house. So I became homeless and she took her phone back. So I had no way to contact my PO wife.
All right, so she had a reason for putting you out of her house though, correct? All right. Did you ever complete any sober meetings?
No.
Did you ever complete parenting classes?
No, ma'am. I did a platform here.
So you have done nothing? All right. All right, the court is going to find violation of condition number 1 true. The court is going to find you guilty. The court is going to revoke. The court will sentence you to 2 years in the state jail facility. You're credit for any time served. Court will ask for the therapeutic community. This will run concurrent with 2024 CR 011631. All right, we can go off the record. So it appears to the court, you may have some other issues going on in your life. When you're released from custody, if you can't find a place to stay, if you can't find treatment, just let the court know. And if I'm here, I'll see if I can find a place for you, okay? All right, good luck to you. All right, who's here on Daniel Montoya?
Yeah. Hi, good morning.
Good morning. So is this one that has a co-defendant or something with Michael DeLeon's client?
No,
Okay.
we're not.
All right, so where are we on discovery?
Go ahead.
Runner, we have uploaded everything we have to Discovery. I believe defense is getting that or is having some issues accessing.
Yeah, I got locked out.
They're like, we don't need to show this to the defense.
Yeah.
The computer system.
Yeah, so I'm locked out. I downloaded a bunch of stuff, but to get we're gonna look at it and talk some more, Your Honor.
All right, Ms. Perkins, can I have a discovery date, 30 days, please, on Montoya? All right, January 14th. We'll see you then.
Okay.
All right, thank you. All right, who's here on Luke Anthony Galvan?
Good morning, Judge. I am Fox.
All right, Mr. Galvan, come down. Are you ready to proceed?
Yes, Your Honor.
Court is calling 2024 CR 1224 State versus Luke Anthony Galvan. Can I have parties announced for the record for the state?
Yes,
Defense?
Eric Baker for Mr. Govon, Judge.
And are you Mr. Galvan?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Luke Anthony Galvan who was placed on deferred adjudication in 2024 CR 1224 for the offense of aggravated assault with a deadly weapon on May 6, 2024 for a term of 4 years? Is that you?
Yes, ma'am. Yes, ma'am.
All right, state.
Yes, Your Honor, violated condition number 1 on or about the 31st day of October 2024 in Bear County, Texas. Defendant Luke Anthony Galvan committed the offense of assault violation of condition number 1.
How do you plead to that? True or not true?
True.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, there is, Your Honor.
Yes.
It is to adjudicate guilt and revoke the individual off of probation. He's sentenced to 2 years in the Texas Department of Corrections. And he is also to put into the misdemeanor cases in County Court 4 and County Court number 13, Judge.
All right. Are you asking the court to follow that agreement? Are you waiving your right to appeal?
Yes, ma'am.
All right, the court is going to grant the motion, revoke, sentence you to 2 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be restitution and no contact with Robert Perales, Perales. All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Who's here on Reggie Rice? All right, did the state tender an offer?
So no, Judge, today was set for discovery compliance. At the last setting, I gave ADA Ariola a flash drive to get me the body cam because none of the body cam can be downloaded on e-discovery. After that, on December 10th, ADA Ariola texted me that he was no longer in this court, but still had my drive. Asked if I still needed the discovery. I said yes. So he was putting it on there and then ran into some difficulties, and now he's on vacation, and I think messaged ADA Edelman last night maybe about it. And so I don't have the body cam.
All right, Norma, recall this for the week of January 6th for discovery. All right, we're gonna come back on January 7th and they're gonna have your discovery for you, okay?
Okay, thank you, Judge.
All right, thank you. Roger Mims? I'll get it to her.
We're ready, Judge.
So, my understanding, all discovery received. State, did you tender an offer on Mims? Was an offer tendered?
No, Judge, that's kind of what we're waiting for. I think Ms. Galloway wants to look at just a couple more things before she gets me a formal offer to make sure that we're all on kind of the same page here.
All right, Norma, recall this for the week of January 27th.
I can do the 28th.
All right, you're gonna come back on January 28th. State you need to be prepared to tender an offer on that day.
Yes, Judge.
Thank you, Judge.
All right, thank you. Guadalupe Delgado. What are you doing? Oh, yeah, that's true. Okay. See, I don't, you know what? I tried, in my family, we tried not to necessarily remember tragic dates, but I understand.
We have to.
Yeah, you know, they still have that, those two persons still in space that they can't bring back home. Oh, they've been up there for way past their time.
It's a really good documentary. I'm into stuff like this.
Yes.
Very. It's a really good documentary. It's sad, but very good.
Yeah, you know what you need to do? You need to get with Cornelius Cox.
Oh, why?
Okay, let me just tell you. Cornelius is very, very into history.
Oh, yeah.
And he does investigations. So maybe you guys can write books like Belcher
Sure,
did.
they're thorough and good.
Oh, they are. Oh, Mr. Cox, Mr. Toshi. Let me let these two people meet. He is very into history and documentaries, and I told him you were too. I always fear for you when you go back to Dallas, though. I don't know.
For Albert Tritus, he was here.
All right, then. Sounds like he's gonna come back in the afternoon. Richard Ortiz.
Present, Your Honor.
All right, what are we here for in this case?
Judge, Mr. Ortiz is on deferred adjudication. He picked up a new number 1 on November 23rd, approximately 30 days ago. We're just getting new information on that. Probation wants to put him back on. However, we have to resolve the initial case, and it's not indicted. Nothing's going on. Well, I mean, not nothing's going on, but they need to test the drugs, I'm sure. It's a 1-4 grand case and, apparently he's got a $3,000 bond right now, which he can't make. I don't know if the judge the court would consider him doing a PR bond or having him interviewed for a PR bond.
Norma, please have him interviewed for a PR bond.
And then we would like to come back. Whenever the court would like us to come back.
All right, State, where are you on the Richard Ortiz? There's a new number 1 within the motion to revoke.
I haven't
It's a
even,
drug case?
I haven't even conferred with the state judge because I mean, it's so new that I knew they wouldn't have anything.
No. All right, Ms. Ferguson, recall this for 30 days.
I can do 14.
Sure.
Ms. Abrams? All right. And we'll make sure that something happens by that time, okay?
Thank you, Judge.
Yes.
We're all done, right?
Yes.
Okay, so good. Have a seat.
Nathan Martinez. Okay. All right. Just wait one second.
Yeah.
You waiting for Jayson?
Yeah, he went into the back. All right, just have a seat. We're going to call you right back up when he comes back. All right, Doug. Oh, okay. Just give me 2 seconds. Delgado. Guadalupe Delgado. All right, what is happening with Delgado?
Deferred with the state judge, there's an offer. He's not a US citizen, so I'm talking with the MAC about a Padilla letter. Just to inform him of his rights. State's okay with resetting so that we can get the Padilla letter, have everything clear.
And is he a Spanish speaker?
He is.
All right, attorneys, if your client wishes to speak to the court in a language other than English, you need to let the court coordinator know so that we can get an interpreter here. All right, Ms. Ferguson, recall this for the week of January 13th. All right, January 14th, once you sign the reset form, you're excused.
All right, thank you, Judge.
All right, thank you. Nathan Martinez.
Judge, at the last setting, I had made a counter offer to Jayson.
Excuse me.
Stand up, go over there.
No, not stand up, go over there. She's excused from the court unless she's on the docket. And if she's on the docket, she needs to go into custody. No, we can't have that. That's okay. Here's the thing. Excuse me, miss. Miss. All right, so let me explain something to you. I understand. All right, but we can't have that in court because when that happens in court, you know what ends up happening? Everybody gets angry and then the next thing you know, they're fighting. All right, so are you able to stay calm and composed? All right, so you're gonna have a seat on this side on the back row, okay? You're welcome, but go on the back row, miss. All right. So,
All right, when we were last here, I gave Jayson a counter offer. And we're kind of like, I don't really know exactly what's going on because he did communicate that to David Lunan, who basically said, well, we might be able to convince Mr. Gonzalez to.
No, I don't want.
Well, I mean, I'm trying to say that we don't have a plea bargain. We don't not have a plea bargain.
If you don't mind, I might be able to.
Yes.
I think what we're asking for is like maybe another week or so that the counter offers can go back and forth, Your Honor, and that could be allowed because this would be a case that would be set off probably closer to July or so because it is a capital and a murder associated with this individual. So I think that if that's amenable to make.
I mean, as long as we can start to get some sort of solid footing, because basically what's been happening, and I understand is I say this and they say, well, maybe, and then they offer me something.
All right,
said,
so
well,
this is what's
maybe.
gonna happen. What's gonna happen is the last date for a plea deadline date in this case is going to be January 23rd. After that, it's going to trial if agreement's not worked out.
Thank
you. If, somebody upstairs wants to come down and be a part of the conversation, they can come down and be part of the conversation. But the 23rd is the last day. And after that date, The court will not accept any plea bargain agreements without good cause, otherwise there'll have to be a plea open to the court.
And I understand that, Judge. The only thing that I would ask is maybe if the DA's office could be instructed to maybe let me know before the 23rd, so we don't walk in on the 23rd and now we have some offer and he gets 5 minutes to think about it.
No, I'll get with Ms. Kramer probably in the next couple of weeks or so, right after the, probably the first of the year.
All righty.
Thank you, Judge.
All right,
May I
thank
be
you.
excused?
Yes, you may be excused. All right, so, are they related to this case? All right, so, all right, so, all right, so here's the thing. People from either side are not allowed back in the courtroom. That's what I'm gonna have to do, because we're not gonna have a brawl in the 187 district court. So, no. So this is what's gonna happen. If there's somebody, if there ends up being an agreement and there's a victim impact statement, that's why we have Zoom. So people don't have to come in. So the defendant's family is not gonna be allowed in the courtroom. If they're testifying, it's gonna be by Zoom. If it's a jury trial, of course, we'll need them here. But nobody's family is allowed to come back in the courtroom on this case. They can testify by Zoom. All right, thank you.